Good morning. Happy Sunday. This is just a quick video to cover a few basic things. Number one, Lane Myers is still in jail. I guess this is a public service, posted an old live stream that he did with Lane Myers, but he posted it new without any context, not telling anybody that it was an old... Oh yeah, we have a rooster again, by the way. Luck of the draw. There's the rooster down there. Hello, rooster. Can you tell which one's a rooster? Anyway, the video was an old one, but it apparently confused a bunch of people in this is a public services channel, and at least one of them came over to my channel to rub it in my face about how dumb and wrong I was. See the bunny down the bottom by the tree? See the bunny? Hello, little bunny. Bunny, bunny, bunny. So apparently it confused a lot of Lane Myers fans because they're retarded. But no, Lane Myers is still in jail. There's a website called VineLink, VineLink.com, where you can go to and you can check, as long as you know the state and the offender's name, you can look up the offender and you can find out their incarceration status. And he is still in the Pima County Sheriff's Jail. And that rooster is very, very concerned about letting everybody know that he is in fact a rooster. He's a Delaware, 80% chance female, and he defied the odds. We're thinking we might have a Rhode Island red rooster too in one of the juveniles that we've got. So yay, more roosters. Anyway, the other thing is depositions. In the New Mexico case, which I have not been following, don't really know anything about. No one's posted any paperwork on it. He did a couple of depositions. That's what everybody's telling me anyway. And he did awesome, and he caught everybody in all these lies, and he did such a great job on his depositions, and he's such a master attorney. Well, I've never watched them. Somebody sent me a link to the camp host Doug Downey, I want to say, did that in air quotes depositioned, and instantly I knew, wait, this isn't a deposition, because there's no deposition officer there. Normally you have to have some sort of a court reporter, some sort of a clerk, somebody who first of all administers the oath, and second of all will take the transcript. So that wasn't present. It was just Lane Myers. It was I guess the district attorney or assistant district attorney for whatever county it is in New Mexico, the witness, and that was it. Just three people on the line. And so I double checked, and you can find it if you work hard enough. It's the New Mexico Supreme Court Criminal Procedure for District Courts or something like that. I forget the exact name of the title. Article 5. But it lays out witness statements and depositions, and they're two different things. A deposition, there has to be a deposition officer there swearing the witness in, etc. Witness statements are not taken under oath. Now, whether or not anything in those statements will come in is highly suspect. The purpose of taking a witness statement is to find out what the witness saw, heard, touched, tasted, smelt. It's to get their sensory impressions. You know, what did you hear? What did you hear him say this? Did you hear him say that? What did you know at the time? It's not to grill them on the law, their knowledge of the law, whether or not they took an oath, etc., etc., etc. All these things can be proven by other methods if they're even relevant. And I'm going to once again argue to you that whether or not a police officer swore an oath to the Constitution is never going to be relevant. It just won't be. Sorry, not in today's society. So they were witness statements, not depositions. He may be able to use them for impeachment purposes, but I highly doubt it. You might notice if you actually watch those that the attorney, I only watched like maybe a half hour of each of them. But even though there were a lot of very objectionable questions that Lane Myers was asking, he was badgering the witness, he was asking the same question over and over and over again. He was telling the witness that they could not take the fifth, not that they would need to take the fifth, but you always have the right to plead the fifth. There's no There was no court order granting them immunity from anything that would remove their ability to plead the Fifth. So there were so many objectionable things in there, but you notice that the district attorney didn't object. Why? Because those witness statements aren't coming in as evidence. They are not sworn statements. It wasn't in a deposition, and there was no opportunity for the district attorney to cross-examine under oath because they weren't under oath. It wasn't a deposition. I mean, it just wasn't what Lane Myers claims it was. I mean, he put up the title saying they were depositions. They clearly weren't depositions. They were witness statements. So his knowledge and understanding of what is even going on, of what the procedure is, of how things work is just so incredibly suspect. Finally, on a completely different note, one thing that I had missed in the flurry of motions being filed for rehearing and rehearing en banc was in Earl David Warden's case in Texas, in his appeal. The state filed motions for rehearing and rehearing en banc, and Earl filed motions for rehearing and rehearing en banc. I did not know that the state had also filed the motions. They disagree with some of the language used in the opinions, and they want clarifying language, etc. So they are also wanting to have the appeal reheard. So it gets much more likely that the appeal is going to get reheard, which is good news for Earl. And once again, I think Earl was done a little bit dirty, and I would like to have a fair trial, a clean trial, and that way no one can say anybody was done dirty or anybody wasn't heard, or that anybody had evidence presented that shouldn't have been presented, or etc. So I want a clean trial, and so I still hope it gets remanded back for a clean trial to put this baby to bed. Another thing of note was that the Court of Appeals had asked both Earl's attorney and the state's attorney to respond to the other side's motions. And Earl filed, apparently on the 29th, a request for leave to file a late response, and so that'll probably get granted. The state hasn't filed anything that I can see. But one thing I've learned from Texas courts of appeal following this Earl Worden case is that the state can pretty much delay and procrastinate as much as they want to without any repercussion, because why shouldn't the Court of Appeals let them get away with everything? I think it's pretty disgusting, but and the reason why I think it's pretty disgusting, like if Earl's attorney delays things, well, that's Earl's problem because Earl's in court. But if the state delays everything, that's still Earl's problem because Earl's still in court. You know what I mean? It's like the state doesn't have any stake in a speedy appeal, but Earl does. And that's why I think it's dirty to Earl to have the state procrastinate, delay, and get away with it. Anyway, I got things to do today and places to be, so thank you for watching, and have a great day.